Today we're going to be discussing the prevention of workplace harassment in business. We start by defining what harassment actually is. It's any unwelcome conduct that creates an offensive, intimidating, or hostile work environment. And one thing we have to look at is the conduct is only illegal if it's based on one of the characteristics protected by federal or state law. We have to remember that not all harassing behaviors break the law, such as a supervisor or boss that's just a mean person. That doesn't constitute breaking the law for the purposes of what we're discussing today. Also, teasing an unprotected class, such as Dallas Cowboy fans, would not fit the context of unlawful harassment. When we talk about unlawful harassment, we talk about laws prohibiting discrimination. Title VII of the Civil Rights Act of 1964 is a federal law that prohibits employers from discriminating against employees on the basis of sex, race, color, national origin, and religion. It generally applies to employers with 15 or more employees, including federal, state, and local government. Employees that fall under this criteria are known as a protected class, and sometimes they've been referred to as protected status. For additional information, you can visit the EEOC website at www.eeoc.gov. Coincidentally, the EEOC is the agency of the federal government created by the Civil Rights Act of 1964 with the purpose of interpreting and enforcing federal laws prohibiting discrimination. Businesses and entities have the right to improve upon the definition of harassment to provide employees with greater rights. A good example was taken off of a New Mexico County government website that included additional classes for protection. Their definition of harassment includes verbal or physical conduct intended to threaten, intimidate, or coerce, verbal or physical conduct that has the purpose or effect of unreasonably interfering with work performance, or that it creates an intimidating, hostile, or offensive working environment, and the uttering of words or the display or circulation of written materials or pictures that are degrading to individuals or a particular sex, race, age, national origin, disability, religion, sexual orientation, or political affiliation. Sexual harassment includes, but is not limited to, unwelcome sexual advances, requests for sexual favors, making jokes of a sexual nature, displaying photographs, picture messages or posters that show nudity, displaying words of a sexual nature, commenting about a person's appearance or dress, or other verbal or physical conduct that is sexual in nature. So in this case, the county has added disability, sexual orientation, age, and political affiliation to its protected class. Sexual harassment is a serious problem in the workplace. It is not just the victimized employees who experience emotional injuries of sexual harassment. It may also be the harasser who feels the punishment of the laws that prohibit sexual harassment. We have to understand that society and courts are no longer tolerating sexual harassment in the workplace. We must learn to draw the line between acceptable behavior and unlawful harassment. We must define sexual harassment in the workplace just as the courts have defined it. So, for our purposes in the federal context, sexual harassment is considered to be a form of sex discrimination under Title VII of the Civil Rights Act of 1964. Accordingly, the EEOC, unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitutes sexual harassment when submission to or rejection of this conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment. So you can tell by the county they included everything as part of their definition as well, so that the EEOC definition matches the definition for the particular county. So when we move forward and we start looking at the types of sexual harassment claims, this is broken up into two different types. One is quid pro quo. Quid pro quo is this for that. It occurs when a supervisor or one in authority position requests sex or a sexual relationship in exchange for not firing, otherwise punishing the employee, or in exchange for favors, such as promotions or raises, and potentially could lead to placing an employee on particular shifts, granting days off. So the extent of quid pro quo is almost endless. The other part of this, or the other type of sexual harassment, is going to be a hostile work environment. So the hostile work environment, sexual harassment that occurs through this presence of demeaning or sexual photographs, jokes, or threats. Its inappropriate behavior or conduct must be so persuasive as to, as the name implies, create an intimidating and offensive work environment. So when you look at the slide, it has to be pervasive and it has to create an intimidating and offensive work environment to fit the criteria. The problem is the courts easily define sexual harassment. It's very difficult to apply the definition to a set of particular facts. Court opinions seem inconsistent about whether sexual harassment has occurred, sometimes deciding differently in cases with very similar facts, particularly in hostile work environment cases, where it's more difficult than in quid pro quo situations to prove that harassment has occurred. The U.S. Supreme Court has held that employees may defend themselves in a hostile work environment case brought against them for actions of a supervisor or managerial level employee by arguing that they took reasonable steps to prevent sexual harassment and made efforts to correct harassing behavior. Employers must also show these steps have been accomplished through documentation of existing or exercising reasonable care to prevent and correct the harassment, such as training employees in management and addressing prevention through policies and procedures. And we'll discuss this here shortly. Employers may also argue in court that they are not liable if any employee did not take advantage of available reporting or remedial measures to complain about incidents of sexual harassment. So when we look at factors that a court will consider in a hostile work environment cases, some of the things that they examine is going to be the frequency of the alleged inappropriate behavior. I know in our particular case where I'm employed, one time doesn't necessarily mean that it's sexual harassment. We've implemented policies and procedures where the person, sometimes someone may be telling a lewd joke or a joke that's inappropriate, and somebody else may wander by and hear it. The opportunity is afforded to the person to apologize. Sometimes it's not the intention for this type of behavior to occur to be witnessed by somebody else. So the opportunity is there to apologize for that behavior, and that's one of the first steps in correcting it. Some other things that the court will look at is the severity. So, some type of joke may be seen less severe as some other type of persuasive activity. Conduct of the victim. So did the victim go along with the joke? Did the victim laugh? Did the victim not seem offended? So the conduct of the victim is weighed in as well. Context of the alleged harassment. Again, it's going to be dependent on a case-by-case basis what the context of the harassment is and what the claim is. If it was reported, the time that it was reported, the time it took from the alleged offense to occur to when it was actually reported is going to be considered as well. You look at the size of the employer's business, and then of course the nature of the employee's business, the employer's business, because that's going to determine and provide the context for the type of harassment that occurred or sexual harassment that occurred as far as what the employer does as part of their business. So when we look at strategies for prevention of sexual harassment for business, some of the generic ones across the board that seem to be working is you're always going to implement a clear sexual harassment policy. You have to clearly define what it is and understand, at least in your personnel manuals and your policies and procedures, that it's not going to be tolerated. So people will be aware that that type of behavior is not going to be tolerated within the workplace. Disciplinary action up to and including dismissal shall be served for anyone involved in harassment of another. So it needs to be taken seriously. One thing that's good about our textbook is it always explains that if management doesn't do it, staff will not follow. The ranks will not follow. So if it's taken seriously from the top down, employees will model that type of behavior. You also have to develop clear procedures for filing sexual harassment complaints. Clear procedures will make sure that anybody can file a sexual harassment complaint if it occurs. So this is going to be part of going back to businesses are going to deter that by providing a venue for people to report it. All complaints will be investigated, and this is a good practice because not only can investigations be done to find out if these allegations are true, but it's also done to clear people. So that way businesses can ensure that not only what they're doing is working, but it's also they need to find out if employees are in fact telling the truth. And then of course, retaliation against anyone who complains about sexual harassment shall not be tolerated. So anytime you have this type of or this nature of complaint, it needs to be clear to everybody involved that people are free to make these type of allegations if they think that they've been harassed, and there should not be retaliation either by management and including the person that these type of claims may be directed at. So no retaliation against anyone is not tolerated. One other thing, or a couple other strategies, is train employees. You have to train them. You should train them at least once a year, especially with harassment and sexual harassment. Above and beyond that, other entities have gone on to train supervisors and managers differently and more frequently than they would regular employees. So that way supervisors and managers actually have a better understanding of the parameters and what they need to do when it's reported to them. Sexual harassment prevention guidelines. One should always monitor the workplace, especially owners, upper management. They should always monitor the workplace and be in the workplace and the business. Talk to employees, see how their work environment is. Observe physical work environment for any type of red flags, questionable postings, posters, photos, and then communicate with management and staff to gain insightful input and identify any red flags. And this should be a constant. Behavior of upper management. Understanding that all complaints are taken seriously and the business has an obligation to investigate. Anytime a complaint is made, as a business owner, as a manager, as somebody in upper level management, you have an obligation to do that investigation. Again, you need to see that if it's unfounded, unsubstantiated, or substantiated. If it's valid, you need to follow policies and procedures, and you need to do it quickly. And finally, if any information is needed, you may contact the EEOC, which is pretty much where this whole program came from. And then another one locally, or more on a local level, is going to be New Mexico Department of Workforce Solutions.